The graphic, please be seated. The President. The trial chamber is now back in session. For the next proceeding, the chamber would like to ask the defense counsel whether the counsel or the accused himself has anything to say in response to the co-prosecutors regarding the release on bail, which the co-prosecutor responded this morning. Thank you.
Merci. Merci, Monsieur le Président. La défense n'a rien après les explications de ma
The explanations of yesterday.
Est-ce que la traduction...
Now, is it clear? Can you hear the English? Or is it? Can you? The interpreter is asking if you can hear the English. Yes. Yes. Okay. So, the defense has nothing to add after what the co-prosecutor presented to us. The defense stands by its position, and the defense has not been convinced by the co-prosecutor, respectfully said.
The President. Next, the chamber would inform the civil parties' lawyers for their request to express their comments or opinion in response to the request made by the defense counsel for the release on bail during the entire proceedings of the trial. The trial chamber will consider this matter tomorrow in order to seek guidelines on the provisions or rules in order to clarify the right to make comments or observations by the civil parties' lawyers. And we will inform you the scheduling also on Monday, the 6th, next week. For our next proceeding, please, the lawyer.
Oui, Monsieur le Président.
Yes, Your Honor, if the chamber must deliberate on the request from the civil parties, the defense would wish to express itself on this question. We have not expressed, the chamber made a decision, the civil parties asked it to revise the decision. The defense has something to say about this request to revise this order. So I would like in a few words to express the defense's position concerning this request to review.
The President, please the lawyer for the defense, for the accused.
Your Honor. So, the defense took note of the Chamber's decision indicating in compliance with pursuant to Rule 82, indicating that the civil parties did not have to be examined in the hearing for release. The civil parties are requesting the Chamber not to interpret the rule, but to modify the rule. I believe that the judges always have the power to interpret, and I have been fighting for years to grant the judges the possibility of interpreting the rule of law. But here it's different. We're not asking you to interpret the rule, we're asking you to correct it on the grounds that there would be an error. So I'd like to remind you that only the plenary, the judge's plenary, has the jurisdiction to modify the rules. The Chamber does not have the jurisdiction to modify the procedural rules. I do not see how we can make this request. And concerning the substance of what I'm saying, I can imagine that if the plenary assembly of the judges, in its wisdom, has written out the internal regulations in this way, it is because the plenary believed that the hearing concerning detention should not concern the civil parties. And this sends us back to this discussion that we already had here on the role of each one of the parties in the criminal proceedings. The civil parties are welcome. We welcome them to express their suffering. Of course. But anything concerning release, anything concerning the sanction is a question that depends on public order. That is to say, a question that depends on, that hangs on the responsibility of the prosecutors and on the decisions rendered by the Chamber. The civil parties can make observations on detention or on release only if this has an impact on their own interests. And when I'm speaking about their interests, I'd like to remind you that we are only speaking about the reparations that the civil parties might request. A civil party such as this was explained to us the other day will never be satisfied by the sentence itself. But detention is part of the sentence. So here we are not in the domain of the civil party itself. So and I believe that when the rule was established by the judges' plenary, I believe that that was the idea. So it is true that the pretrial chamber is trying to find the way in this area in the same way as the ICC is also trying to find its way. We are, each one of us here, trying to build law, and in particular the law for the victims. Let's build this law, but let's also try to establish milestones. Who is doing what in these criminal proceedings? And I believe that the ICC, after having at first, in the Lubanga case, opened quite broadly the victims' access to the victims' access to the proceedings, the ICC rendered a second decision in which it restrained later on, because otherwise it would be impossible. Let's be realistic, and I believe that this was what the judges had in mind when they established the internal rules. In this first trial, we have 94 civil parties. In a second trial, there will be hundreds of them. Are we going to be examining hundreds of civil parties on all the topics? You can see that by trying to do things too well, we are going to hinder the idea of justice itself. So I believe that we're obliged to set milestones. And I will repeat it again to the civil parties. We will hear you. We will hear what you have to express to us. But please, do not venture onto areas which are not yours. And you will be paying service to justice, but also to yourselves. Thank you.
The President, the trial chamber does not allow any civil party lawyers to express their comments. So let me move on to our next proceeding. I would like to request the co-prosecutor to read the agreement on the facts between the co-prosecutors and the defense counsel, and as well as the uncontested facts. The floor is yours.
Thank you, Mr. President. I will try to make this as clear and as brief as I can. But for the sake of clarity and remembering that in this court we have transcripts that will serve as the record, I will endeavor to put as much information in my address to you so that the record reflects accurately the information. Therefore, if you'll bear with me, and I'm addressing you today on this matter in English because this is how we set it up with the translation, even though the agreement has been done on the French version. However, the translators have copies, written copies in all three languages of what I'm about to say. But to clarify, as we've said earlier, on 31st of January of this year, we forwarded to the defense extracts of the closing order separated into separate factual allegations to seek their agreement or comments. This filing, or this document, was later filed, our document that we had sent, was filed into the record on 11 February 2009 under the quote E5/11/2-7. More precisely, ERN number 002 82, 115, to 002, 82, 155. So this is the document that was sent to the defense and filed. We have not received an official filing in terms of their response, but this will serve as at least the recorded version, and I understand there will be an official, or there has been an official filing. So I propose to read the agreed facts or the not disputed facts. In other words, things that the defense agrees to or does not contest within this trial. And I propose to do so by referring to first sections that were duplicated from the indictment: introduction, establishment and structure of democratic Kampuchea, etc., etc. So to do so by parts, and for each fact to refer to the paragraph number of the filing that was sent to the defense. This is the number that appears in bracket at the beginning of each factual allegation, and as I said, is reflected individually in the filing of 11 February 2009. And I further propose to cover section by section so that it makes a little bit of sense in terms of the factual matters at hand. So again, with your leave, the following facts are agreed. Paragraph 3. S21 was chaired for most of its existence by Kaing Guek Eav, alias Duch. Agreed. Paragraph 5. On 5 January 1968, Duch was arrested and sentenced to 20 years imprisonment for breaching state security in relation to foreign states. Duch was set free following the coup of 18 March 1970. Agreed. Paragraph 7. From 1975 to 1979, Duch occupied posts at S21 when he was aged between 33 and 37. Agreed. Province. That is the section of the introduction. I would ask my colleague to confirm.
The President, please, the Defense Counsel.
Your Honor, I confirm in the name of the Defense Counsel the agreements that were, the points agreed that were here presented.
The President, please, the co-prosecutor continue.
On to the section titled Establishment and Structure of Democratic Kampuchea. The following facts are agreed. Paragraph 10. On 17 April 1975, the Army of the Communist Party of Kampuchea, CPK, the Kampuchea's People National Liberation Armed Forces, KPNLAF, entered Phnom Penh, and the CPK seized national power.
Pardon, un problème de matériel pour l'accusé, si on pouvait lui donner...
An equipment problem for the accused, so if we could give him another headset.
The President, please, the co-prosecutor, you may continue.
Start again. On the section titled Establishment and Structure of Democratic Kampuchea, The following facts are agreed. Paragraph 10. On 17 April 1975, the Army of the Communist Party of Kampuchea, CPK, the Kampuchea People's National Liberation Armed Forces, KPNLAF, entered Phnom Penh and the CPK seized national power. Agreed. Paragraph 11. With the end of the civil war against Lon Nol's Khmer Republic, the CPK's stated policy was to, quote, pass to, quote, the next phase of making socialist revolution, unquote. Agreed. Paragraph 12. During the 3 years, 8 months, and 20 days that followed, the CPK exercised effective authority over democratic Kampuchea and pursued a policy of completely disintegrating the economic and political structures of the Khmer Republic and creating a new revolutionary state power. Agreed. Paragraph 13C. The elimination of officials and supporters of the previous regime. Agreed. Paragraph 14. Many of the CPK's policies required the transformation of, quote, new people, quote, into peasants. Agreed. Paragraph 15. New people were broadly made up of evacuated city dwellers and peasants living under Lon Nol control until April 1975, as distinct from old or base people who were essentially peasants from areas already under the authority of the CPK during the Khmer Republic period. Agreed. Paragraph 16. Politically motivated extrajudicial executions were committed at the outset by military units and continued thereafter in security centers throughout the country. Agreed. Paragraph 17. In February 1975, the CPK held a Popular National Congress of the National United Front of Kampuchea, at which it publicly announced that 7 so-called Khmer Republic super traders were to be summarily killed for treason. Agreed. Paragraph 27. Numerous persons, rightly or wrongly, linked to the Khmer Republic or its purported social class foundations were punished or summarily executed by the CPK in the days and weeks immediately following the liberation of Phnom Penh throughout the end of the regimes. The following facts are not disputed without comments as it relates to the establishment and structure of democratic Kampuchea. 13A. The forced transfer of residents of Phnom Penh and other former Khmer Republic strongholds to the countrysides. 13B. The creation of party-controlled agricultural production cooperatives where people were made to work under extremely difficult conditions to increase food production. Paragraph 18. The Congress also declared that lower-level Khmer Republic personnel would be welcomed by the revolutionary forces, quote, provided they immediately cease their service to the 7 traders and stop cooperating with them, unquote. Paragraph 19. Any such Khmer Republic personnel who did not immediately defect to the CPK were vulnerable to summary execution. Paragraph 23. All punishments specified in Article 9 of the DK Constitution were applied arbitrarily. Paragraph 24. The CPK established no appropriate facilities for captured enemy combatants or civilians, nor any mechanism to challenge the legality of their arrest, detention, or punishment. Paragraph 25. The legal structures were replaced by re-education, interrogation, and security centers where former Khmer Republic officials and supporters, as well as others accused of offenses against the CPK, were detained and executed. I would ask the defense to confirm both the agreed and not disputed factual allegations.
The defense confirms that concerning the readings that just were done concerning the historical and political context, and as we mentioned before, there's an agreement concerning a certain number of paragraphs, and other paragraphs are also not contested, as we have mentioned earlier. But maybe in order to understand your chamber a bit better, maybe we should specify that in the document that we submitted to you yesterday, there are sometimes passages in italics, and these are comments from the defense, but we will not speak about these today. And in your version, these comments are included. Thank you.
Thank you, Mr. President. The next section regards the establishment of S21. The following facts are agreed. Paragraph 29. On 15 August 1975, Duch attended a meeting with Sun Sen and In Lorne, alias Nat, from Division 703 of the RAC, at the Phnom Penh train station, for the purpose of which was to plan the establishment of S21.
Monsieur le procureur, un petit peu plus lentement, s'il vous plaît, pour la traduction.
Mr. Prosecutor, could you please go a little bit slower for the translators? Thank you.
Except, as I have mentioned to your honors, the translators have all three versions of the text. So I'm trying to hopefully finish before 4, but they have the text, so we will... Agreed, paragraph 30. Sun Sen appointed Nat as chairman of S21 and committee secretary, with Duch as his deputy in charge of the interrogation unit. Agreed, paragraph 31. Following the meeting, Duch brought a number of his former M13 staff to Phnom Penh to join forces with the Division 703 personnel. Agreed. Paragraph 32. S21 became fully operational in October 1975. Paragraph 34. In March 1976, Nat was transferred to the General Staff, and Duch replaced him as chairman and secretary of S21. Agreed. Paragraph 36. Duch confirmed Kim Vat, alias Hor, a former Division 703 cadre, as his deputy, responsible for the day-to-day operations of the office. Agreed. Paragraph 37. The third member of the S21 committee and head of S24 was Nun Hoi, alias Hoi Srei. Agreed. Paragraph 38. Under Duch's command, S21 was divided into distinct units, each with its own function. Agreed. Paragraph 38A. The defense section was administered by Hor and his subordinate, Fal. Agreed. Paragraph 38C. Susti was responsible for maintaining the document unit, and he reported to Duch through Hor. Agreed. Paragraph 38E. There were also a number of other units which included photography, medicine,